All right, so we are going to go ahead and get started. The purpose of the webinar this morning is really to give you all some good background in the confidentiality laws that have to do with victim services. The types of laws that govern the work that we do, the laws that are in place in the state and federal level, and some best practices around confidentiality as well. So all of those things, all of those pieces, we're going to discuss today. So we're going to do a couple of quick polls just to kind of see where everybody is in terms of knowledge and what everybody's kind of doing within your agencies. So the first one is your agency's confidentiality policy based around HIPAA? Is it HIPAA compliant? So I'm going to give everybody a few seconds to vote, and then we will look at the results. Okay, I'm going to give about 5 more seconds because about 65% of you have voted. So I'm going to give just a second for everybody to click one. All right. So as you can see, about 65% of you said that yes, your agency's confidentiality policies are based on HIPAA standards. So the vast majority of you, and then there's about 25% that are not quite sure where that is based. Okay, the second question I have for you, which of the following has the strongest confidentiality protections? Is it HIPAA, FVPSA, VOCA, VAWA, or do we think they are essentially equal? So what are your thoughts on this? I'm going to give, again, a few seconds for everybody to vote for me. All right, just a couple more seconds for everybody to get their votes in before we close it up. All right. It looks like, again, the majority of you are looking at HIPAA, that 56% roughly. And then about 19% say VAWA, 13 say VOCA, and 13 say they're basically equal. And nobody picked FVPSA, so that's interesting. Last question. How many of your agencies employ, not just refer to, but employ on site, licensed clinical therapists, nurses, or other medical professionals? Okay, I'm going to give us about 10 more seconds to let everybody get a chance to vote. All right. So it looks like about 76% say that you employ neither medical professionals or therapists, which was what I was expecting. And then about 22% employ either therapist or both therapists and medical professionals. All right, so that was just to kind of give me an idea of where we are all at and what types of organizations and what types of providers that you had within your agency. So I appreciate you taking the time to answer that for me. So the first thing that we're really going to go over and talk about this morning is HIPAA. Most of you said that your agencies base your confidentiality rules around HIPAA, and that HIPAA is the strongest of the protections. So I really want to take the time to go over what HIPAA says, what it looks like, so that we all really kind of have the same grounded understanding. So HIPAA is the acronym for the Health Insurance Portability and Accountability Act that was passed by Congress in 1996. HIPAA regulations apply to covered entities, and in this case we're talking about health plans, so insurance, healthcare providers, and healthcare clearinghouses. So hospitals, doctors' offices, primary care physicians, surgeons, mental health professionals. The primary goal of the law is to make it easier for people to keep health insurance, protect the confidentiality and security of healthcare information, and help the healthcare industry control administrative costs. The HIPAA privacy rule creates a minimum standard for protection of private protected health information, regardless how that health information is maintained. So HIPAA covers health information, whether it is in paper files, whether it's stored electronically. And HIPAA, most of the law, if you read the text of the law, is really concerned with permitted uses of health information and when consent is required by patients and when consent is not required. And the interesting thing about HIPAA is that HIPAA makes the assumption that information will be shared. So it assumes sharing will happen and gives medical staff discretion about when and where that will be shared. Mainly in treatment, medical staff have the discretion to share information with other professionals, with other doctors, payment, healthcare operations, business associates, when organizing healthcare arrangement, affiliated entities like insurance providers, other research institutes, public policy institutes. So there are a lot of places where HIPAA assumes and gives permission that medical information will be shared, which is really interesting. So here is kind of a very, at a basic level, this is the difference between medical services via HIPAA versus medical services via VAWA, or victim services via VAWA, FVPSA, and VOCA. Medical services prioritize doctors' expertise regarding patient information, so that predominantly medical staff are the ones making decisions about health information for patients, which makes sense because when you think about it, what could happen if medical experts and medical staff lack information? You know, we know that doctors can make the wrong call if they don't have information, and that could really easily result in harm to the patient. So it makes sense that in medical settings, medical staff are making decisions and having a degree of control and expertise over patient information. On the other hand, you have victim services rules around confidentiality and consent of information. And under victim service rules, we assume that survivors themselves are the experts on their own lives, and survivors are the ones deciding and using information made available whether they want to share confidential information or not. So in this case, it is the survivors themselves or patients rather than professionals. And again, this also makes sense. What happens if someone without the survivor's approval shares information? The survivor could be located, their information could be outed, they could be targeted by their abuser, and that could very easily result in harm. So you can understand why with victim services, the survivor is in control of their information. So this is from HHS.gov about HIPAA. HIPAA is to assure that individuals' health information is properly protected while allowing the flow of information to provide and promote high-quality health care and to protect the public's health and well-being. So the reason that I asked in that poll question whether any of your agencies actually employ licensed clinical therapists or medical or healthcare providers is because if your agency does not employ those folks, then HIPAA doesn't actually apply to you at all. So if HIPAA is the standard you're going by, but you don't have any of those types of folks on staff, then HIPAA is not applicable to you. And we're going to talk about what is applicable to you. So VAWA, the Violence Against Women Act, discusses the non-disclosure of confidential or private information under Section 40002. And what VAWA says is that in order to ensure the safety of adult, youth, and child victims of domestic violence, dating violence, sexual assault, or stalking, grantees and subgrantees shall protect the confidentiality and privacy of persons receiving services. This is a mandate. And it goes on to say that grantees and subgrantees cannot disclose or reveal personally identifying information collected in connection with services, regardless of whether the information has been encoded, encrypted, hashed, or otherwise protected. Grantees and subgrantees cannot disclose, reveal, or release client information without the written, informed, and time-limited consent of the person about whom the information is sought, unless that is a minor or someone else who is under the guardianship of another. And we'll talk about cases where information can be released as well. It goes on to say, if release of information is compelled by court mandate, grantees and subgrantees shall make reasonable attempts to provide notice to victims and shall take steps necessary to protect the privacy and safety of persons protected by the release. So basically what this means is, in the case of a subpoena or a court mandate to release information, you are required to contact that survivor and let them know that information is going to be released, and B, take the steps to protect that person. So for instance, if information is going to be released that may put them in danger, they may need to be rehoused in a different location. You may need to help them flee or relocate. There are a lot of issues surrounding this. And continuing, information sharing. So here are some cases when subgrantees may share information. First of all, you may share non-personally identifying data in the aggregate regarding services or clients, demographic information, to comply with reporting and data collection. So that first section, number 1, basically means for grant reports, for monitoring reports, for monthly reports, for your VOCA report, for your FVPSA report, that you can share demographic information and numbers data. You just can't share personally identifying information, so names, social security numbers, addresses, those types of things. Court-generated information and law enforcement-generated information contained in secure government registries. So those are things like voter records, driver's license records, and law enforcement generated and prosecuted generated information necessary for prosecution purposes. So things like things collected in the course of a law enforcement investigation that can be released in court. But numbers 2 and 3 will not really apply to those of you who are in victim services. Number 1 is the one that will apply to you. In no circumstances may an adult, youth, or child victim be required to provide consent to release of information as a condition of services, and any personally identifying information be shared to comply with reporting. So number 1 is saying that you cannot require any survivor who receives services from you to sign a release of information form. That has to be completely voluntary and cannot, under any circumstances, be a requirement to receive services. It has to be a choice. And what number 2 is saying is basically reiterating that the only information shared for reporting, evaluation, or monitoring purposes can be aggregate data, demographic data, that it cannot be, again, it cannot be personally identifying information. Grantees and subgrantees must document their compliance with the confidentiality and privacy provisions required under this section. So you must have confidentiality policies and document your compliance. VAWA grantees and subgrantees are prohibited from disclosing any personally identifying information unless compelled by statutory or court mandate. These mandates are the only exceptions to VAWA confidentiality provision, and the statute or court order must specifically address confidentiality in order to constitute an exception. All right, let me break this down for you. Basically, what VAWA is saying is that unless there is a subpoena or court mandate, you cannot release personally identifying information, and that even with a subpoena or court mandate, that mandate has to address confidentiality and how the client's information is going to be protected. Grantees need to limit the information released to the minimum required to fulfill your legal obligation. So again, if a court mandate does happen that forces you or compels you to release information, you need to limit that information release to the minimum required. So you need to release only that information which the court mandates. So if the court, for instance, mandates one certain record, for instance, the court mandates that you release a record of service provision, that does not also mandate that you release therapy notes or other things that are not within the scope of the mandate. However, it is important to note that the best practice per the Office of Violence Against Women, the best practice is to ask the court to quash or invalidate any subpoena that asks for a program's records. So before you comply, the best practice is to speak with your staff attorney or an attorney or legal representation and ask the court to quash the subpoena. I recognize that responding to subpoenas and court orders can raise a lot of unique concerns and questions, and there are some resources that you can go to for help with this. Contacting a local attorney, contacting the Coalition's legal clinic, and the National Network to End Domestic Violence. They also have a project called the Safety Net Project that you can reach out to for resources to address subpoenas as well. So that is VAWA. Are there any questions about HIPAA or VAWA before we move on? And anytime during this process, if you have questions or need clarification, please feel free to ask in your chat box, and I will answer those to the best of my ability. All right, I'm going to go ahead and move on to VOCA, which is the Victims of Crime Act. VOCA is very similar. They echo a lot of the VAWA language. So a lot of this information is very similar to what is set down in VAWA. Subgrantees shall, to the extent permitted by law, protect confidentiality and privacy, shall not disclose, reveal, or release information, shall not release any personally identifying information collected in connection with VOCA, or individual client information without, again, the informed, written, reasonably time limited consent. And those are the important pieces. You'll hear them, you heard them in VAWA, you hear them in VOCA, you'll hear them also echoed in FVPSA, is that informed, written, and reasonably time-limited consent for release of information. If release of information described is compelled by statutory or court mandate, again, VOCA funds, subrecipients of VOCA funds shall make reasonable attempts to provide notice to victims and take steps necessary to protect the privacy and safety of persons. Again, it's exactly echoing that VAWA language. We're talking about attempting to quash the subpoena, attempting to notify the victim, and take reasonable steps to protect the victim in the release of information. Recipients may share, again, aggregate data, court-generated information, law enforcement and prosecutor generated information, all of that same aggregate data. And again, in no circumstances may a crime victim be required to provide consent of release of information, may personally identifying information be used in reporting. But it's important to note, and VAWA speaks to this as well, with regards to mandated reporting for child abuse and neglect and elder abuse, nothing in this section shall prohibit compliance with legally mandated reporting of abuse and neglect. So it's important to note that that language is also included in these laws. And FVPSA, the Family Violence Prevention and Services Act, again, FVPSA echoes that same language that is present within both VOCA and VAWA. FVPSA was authorized in 1984. It is the only U.S. federal funding source dedicated directly to domestic violence shelters and services. So FVPSA not only echoes the language in VAWA and VOCA, but it includes some information about shelter confidentiality in particular. Number one, it includes these core components that programs must provide, and one of the core components required within FVPSA is a safe and confidential shelter. Okay? And so the address or location of any shelter facility receiving FVPSA funds that otherwise maintains a confidential location shall not be made public except with written authorization of the person or persons responsible for the operation of the shelter program. Basically, that means that we all talk as if you work in a shelter agency, you know that one of the major rules within shelter is maintaining confidentiality of persons within shelter. And so FVPSA, again, in addition to echoing the VAWA language that we've already gone over, and I won't burden you with again, reminds us that shelter location is also an important piece of our confidentiality. And FVPSA language, as well as VAWA and VOCA language, is also echoed in the Tennessee State Shelter Performance Standards. So for those of you who work in domestic violence programs or programs with a shelter, I do hope that you are familiar with the Tennessee Shelter Performance Standards. And they also lay out requirements for confidentiality based both on VAWA, VOCA, and FVPSA rules, as well as Tennessee state law is kind of combined into this one standard document. So this is what it says. Shelter programs are to have a written policy regarding the disclosure of information about any program participant. This policy will specify the procedure regarding release of client information to include who may release information, what types of information may be released, what resources the information may be released under, and what conditions it may be released under. So this basically is giving you an outline of what needs to be included in your confidentiality in your written policy. And what it also says is that no person can be compelled to provide testimony or documentary evidence in a criminal, civil, or administrative proceeding which would identify the address or location of a confidential shelter. So, excuse me. So even if in the event that that there are documents subpoenaed from your agency and that you cannot get them quashed, even if that is the case, they cannot include or be compelled or ordered to include testimony that would identify the location of a confidential shelter. Any proceeding involving the shelter or involving a person staying at shelter, the sheriff or any other person serving legal papers or processes must do so by contacting the shelter office by telephone and making arrangements of service. So what this means is that whether it's law enforcement or a court personnel or whoever it is, they cannot just show up at shelter and say, we need to serve this subpoena, we need to serve papers on one of your residents, whatever it may be. They are required by law, and we're getting ready to talk about Tennessee state law, and you will see that this statement here is pulled directly from state law. They are required by law to call the shelter office and make arrangements, not just show up. And one of the things that we hear a lot of questions about from folks, particularly agencies with shelters, because it's a really kind of unique issue, is what happens if law enforcement comes to shelter and says, I need to speak to your client, Jane Doe. What does confidentiality say about that? And the answer is, just like with any other person in the world, you cannot release information, including whether or not somebody is your client or whether or not somebody is staying in your shelter, without a signed release of information form from that client. So if law enforcement calls or shows up, if Department of Children's Services calls and shows up, just the same as if an abuser called the line, or somebody's mom, or someone's job, or whoever. You cannot share information unless you have a signed release. And so your response should always be, I can neither confirm nor deny if that person is a client of ours or if that person resides in shelter, because that is your duty per the law. Now, that is not saying you can't then go to your client and let them know what the situation is that, you know, DCS has called or law enforcement has called, and is this somebody that you would like to communicate with? And if so, we really need a release of information signed in order for us to be able to even tell this person that you are in shelter. So that doesn't preclude communicating with your clients. You should always be communicating with your clients, but regardless of who is seeking the information, you must have that release. So, Tennessee state law. The confidentiality of record centers, the record of domestic violence shelters, and rape crisis centers shall be treated as confidential by the records custodian of such shelters or centers unless the individual to whom the records pertain authorize their release. So unless your client signs a release of information or a court approves a subpoena subject to such restrictions as the court may impose. So just like with VAWA, just like with VOCA and FVPSA, Tennessee, it is also codified into state law. So even if you don't receive federal funding, your confidentiality requirements simply required by state law are still that records cannot be released unless your client authorizes their release or unless there is a court order. And again, just like I said, that you would see it echoed in state law, there is state law regarding the service of papers and processes at shelter, just as we have discussed. So, are there any questions about anything that we've discussed so far? I'm going to check the chat box really quickly and see if anybody has questions. I know that I've given you a lot of information about laws and statutes and a lot of very heavy, wordy information, and I do promise that I will be sending out a copy of this PowerPoint with the recording and everything else, so you will have all this language available to you. Okay. VAWA addresses criteria for victim releases. So these are criteria for release of information forms. They must be specific, written, informed, and reasonably time limited. Grantees must have basically a frank conversation with their clients about why information might be shared, who would have access to information, what information will be shared, and the victim must agree to this. They must be informed of all of this information, the scope of the release. You should talk about the consequences and pros and cons of information release before the client signs it, because they must be informed and understand what they're agreeing to. And it should be very specific, again, who the information is released to, what specific information will be released, how long information can be released, reasonably time limited. And typically, reasonably time limited, the standard for that is 30 days. Now, there is some understanding and some leeway with regards to the fact that we know that if an information release is specifically pertaining to law enforcement with regards to an investigation or prosecution, that is going to take longer than 30 days. So there is some leeway there where that type of information release could be limited to 60 days, but it still needs to be reasonably time limited. It cannot be just endless without limit. And there should be an understanding that if at any point the client decides that they no longer want the information released or that they've changed their mind about release, that release of information is immediately invalidated. And also, we need to be cognizant and thoughtful about the language with which we are presenting the release of information form and the conversation that we have. You should be having a conversation to ensure that the victim understands the release, and that with regards to language access, that agencies must take reasonable steps to provide meaningful access to their programs, which includes release of information forms. If a victim cannot understand, cannot read, cannot speak the language that the form is in, then it cannot be truly informed. There are some circumstances, and we've talked about most of them already, where information can be released. Disclosure for medical emergency. This one is very important and it's unique. If a client has a medical emergency while in your office or while in your shelter or while in your building, you can call for medical response for an ambulance or whatever that may be, and that is not a break of confidentiality. But you should also not be volunteering personal information about why they're at your agency or about their case. Only disclose that information which is pertinent to the medical emergency. So for instance, we have a middle-aged woman who is having chest pains and has lost consciousness. Revealing that level of information which is pertinent to the medical emergency, but is not releasing undue information that is that would be a break of confidentiality. Number 2, disclosure to a legal guardian of a program participant who is either a minor or has otherwise been legally declared incompetent. So releasing information to the guardian. With regard to minor children, the rule provides that both the minor and the parent or guardian sign the release. There is a clarification from the Office of Violence Against Women that if a minor is incapable of knowingly consenting, which means they're too young to read, they're too young to understand, the parent or guardian may provide lone consent. So you don't need both signatures. But if somebody is 12, 13, 14 years old and they can clearly understand, you should be getting both signatures on that release of information form. Release may not be given by the abuser of the minor or the abuser of the other parent. So the offending parent may not give consent. Number 3, disclosure for reporting child abuse and adult abuse. We already discussed this, but it is specifically written into these laws that none of the language should be taken as preventing a mandatory reporting of abuse. Mandatory reporting of abuse does not break your confidentiality requirements. And then disclosure by subpoena or for monitoring or auditing purposes, which we have discussed. And just a few brief reminders. In no circumstances may a crime victim be required to provide a consent as a condition for services. You cannot require any kinds of confidentiality release of information forms as a condition for services. You can't share any personally identifying information with data collection, reporting, or monitoring. And that's why all personally identifying information must be redacted from files when we or OCJP or any of your other funders do site visits and we have to look over client files. That's why we require that they be redacted and redacted well, because it's federal and state law that they be so. And nothing in VAWA prohibits compliance with mandated reporting of abuse. I also want to make a quick note about cloud-based databases. A couple of years ago, and in the last couple of years, since the ALICE database stopped being updated, and we had to, as a state, we spent a lot of time trying to figure out database storage and how data can be collected and stored. The Office of Violence Against Women released some language and some guidance around that. And basically what it says is that grantees are responsible for taking reasonable efforts to prevent inadvertent release of information that is collected through databases or other means. The reasonable efforts apply not just to electronic storage, but paper copies, things stored on computers, or however you may store your data. Reasonable efforts include, but are not limited to, ensuring that the storage provider specifies that the service provider owns the information and ensures that there are sufficient security protocols. And basically what this means is that cloud-based databases are okay, as long as whoever the database is, whatever organization that is, specifies that you as the agency, you as the service provider, is the owner of all information that is stored. That they are not the owner of the information, that they do not make any kind of calls about when information is released, but that you as the service provider are the owner of that information. And that there are sufficient security protocols to protect the information. OVW recommends the use of what is called zero-knowledge encryption, and that is where the encryption key, so database, everything that's put in the database is encrypted so that hackers can't get to it, and that the encryption key is stored only on the victim service providers, so only on your agency's servers, so that the software company doesn't even have access to information. So that even the software company can only see encrypted, unreadable information, that you all are the only ones who can see the information without encryption. So how do we take all of these kind of various pieces about confidentiality and put it all together? The biggest one, the most important one to understand, is that advocacy programs or victim services programs should follow the most protective confidentiality law that applies to them. So if you're choosing between HIPAA and VAWA, while both are protective, VAWA is seen as more protective and having fewer exceptions. In any event, your program should follow the most protective confidentiality law that applies to you. And what that basically means is even if you employ medical professionals, even if you employ licensed clinical therapists, you should still be basing your confidentiality requirements around VAWA, because VAWA is the most protective of the of the confidentiality laws. Remember that it is survivor's information. At the end of the day, the survivor retains the right to choose when, how, and what personal information will be shared or not shared. Agencies and advocates are responsible for respecting and honoring the victim's wishes and safeguarding any of the victim's information that they collect or hold. Okay? So we want to be sure that we are centering the survivors as the experts and as the owners of their information, and we are safeguarding their information with respect to their wishes. Your program has a legal requirement and obligation to protect survivors' information. Your program should not release information unless you have informed, written, signed, and time-limited informed consent. You may only share the specific information that clients allow you to share. You should have a best practice regarding what happens when a subpoena is issued and how to take steps to address that. And make sure that you know what legal resource that you want to consult with regards to subpoenas and confidentiality issues if something comes up. There's also lots of resources that I've added to this, which again, you will be receiving all of the slides, so you will have all of these great links and resources so that you can delve more deeply into VAWA and HIPAA requirements. So I am going to stick around for just a few minutes and see if anyone has any additional questions or needs from me. I again really appreciate you all being on the line this morning and taking the time to hear me talk about confidentiality for an hour. I will be sending out the link to the recording as well as any additional information later this afternoon. I do want to remind you that when you close out of the webinar, an evaluation form will pop up on the screen, and if you don't mind, if you can take a few minutes to just fill that out. That is, records that we keep for our grant funders, and it gives us an idea of, what things we may need to change or tweak with regards to our trainings. And it also will give you a chance to, I know a lot of times we have multiple folks who may be kind of all sitting in one office watching a webinar together, and it will also give you the opportunity to list out anybody who may be watching the webinar with you so that you can all get credit for the training. So please take the time to do that. And it doesn't look like we have any questions, so I am going to go ahead and sign off. Please know that you can email me at any time if you have any questions or concerns about confidentiality, and I will do my very, very best to answer those. We do have one question really quickly. Do we need to keep discharge or medical records once a client returns from the ER? And if so, do we have to get written permission to keep the records? You shouldn't be keeping any kind of medical records for your clients. That should not be something that you are keeping or storing unless your organization employs medical professionals, which I know a couple of the sexual assault centers have SANE nurses on staff. That's the only time where you should be keeping any kind of medical records in your client files. All right, I am going to go ahead and sign off. I appreciate you all. If you have any additional questions or concerns, please don't hesitate to reach out to me, and I will talk to you next time. Have a wonderful day.